Today's topic of the day is asking expert on making a will. To talk about this, we have Advocate Ragamalliga A. I welcome Ragamalliga ma'am to the session. Welcome, ma'am. And today's moderator for the session is Miss Ansila EKV. For introducing her, she is doing MPhil in Psychiatric Social Work, NIMHANS. I welcome Ansila to the session. And I also welcome all the Zoom and YouTube participants to the session. On to you, Ansila.
Thank you, Lima. Good afternoon, one and all present here. As we all know, a will allows an individual to nominate an executor to ensure that their property and assets are taken care by their loved ones. Writing a will can be a daunting task, especially for seniors. So here we got an expert, appropriate person as the resource person, that is Advocate Ragamalliga. Advocate Ragamalliga has around 15 years of experience in the fields of corporate law, transaction, compliances, litigation, contracts, negotiation and management, and so on. For the last 10 years, she has handled various complex contracts for airports, residential, commercial buildings, road projects, and flyovers, etc. Moreover, she has been an advisor for various company matters, especially contractual and property related. So her expertise and the specializations are in the fields of corporate and commercial law, property law, and contract management. Ma'am, it's an immense pleasure to have you here. Over to you, ma'am.
Thank you. Hi, everybody. Very good evening to all. I hope I'm audible to all of you.
Yes, ma'am, we are hearing.
Yeah, okay. So first, I would like to thank Dr. Vijay, who got me into this, and all the other medical fraternity doctors and organizers who have invited me to give an introduction to will and the importance of making a will. I also would like to thank all the listeners who are all the elderly gentlemen, ladies, and senior citizens and friends who are eager to work out a method or devise a method by which one can deal or dispose of their property after their lifetime. So I'm Ragamalliga here. So I'm basically a corporate lawyer. I handle corporate matters for in Bangalore, Mumbai, Chennai, and Delhi, and I also specialize in property and family matters. So once I start the session, so if anybody has any kind of a doubt there and then, I would like to sort it out. Or if you want to keep it in the end of the session also, it's okay with me. But I want this session to be a little interactive.
So, ma'am, the participants can ask the question in between.
Yeah, yes. So today I would like to give a short brief on the importance of making a will. So I'm sure that most of you would be having some basic idea of making a will, or some of you would have already executed one in favor of your loved ones or friends, relatives, charitable institutions, and many. So first, I would like to take you through the importance of making a will. So by now, after the advent of COVID and other uncertain timely deaths we hear about in media of many of the celebrities and also in our surroundings, and that we all come to know that life is very uncertain, and there is necessity to ensure that whatever properties that we have earned during our lifetime or the benefits which accrues therefrom shall go to whomsoever we desire in such a manner. So this is called making or executing a will. So when a person can be called he has died intestatory death. Interstatement is a person's will, especially the part relating to the personal property. So when a person is called he has died intestatory death is when he has executed an instrument or by bequeathing or gifting his or her property to take effect after his lifetime, and which is capable of taking the effect, then such person is called to said to have died a testamentary death. Otherwise, it would be an intestate death, that is, without making a will, where the succession depends on their personal law, that is, depending upon the religion they belong to. Somebody wants to ask something? Should I wait?
Continue, madam.
Sorry?
Ma'am, you continue, sir.
Madam, hello.
Okay.
Yeah. According to religion, you told no. What
Yeah.
are the types of religion? How it differs, ma'am?
Yeah, so basically, those who are Hindus, Jain, Buddhist, Sikhs, they are governed by the Hindu Succession Act. And those who are Christians, the Indian Christians, they are governed by the Indian Succession Act. And for Muslims, it is their Muslim personal law, the Shariat law, as applicable to either Sunnis or Shias.
Can you deeply explain difference between Hindu and other thing you told, no?
Yeah, I'll be going one by one.
Hello, madam. Only
Yes,
property
sir.
which you have earned, you can give by will, or the property you have inherited from your father also, you can will it away.
Sir, it is whatever share you own in that property. Whatever is your share in an ancestral property, or what you're going to get it from your father, that you can will, your share.
Okay, ma'am.
Okay, so when we are talking about, the importance of making a will, so the next important thing I would like to brief on is about probate. Basically, those who are Indian Christians, like, the ma'am was asking, she wanted to know about the difference. So those who are Christians, they have to get a copy of a will certified by the court, which grants permission to administer the property of the testator. Testator is the one who executes the will. So it is applicable to all Indian Christians. And also to those who reside in the three presidency town, that is Kolkata, the then West Bengal, Mumbai and Chennai. That if the testator resides, or when he is making that will, then he has to obtain the legatee, that is the beneficiary of that particular will, or a executant. While making a will, normally the testator, the executant, he will appoint a executor, so who has to fulfill the objectives of the will. So it can be anybody, their family members, a relative, a lawyer, a chartered accountant, or a district registrar, in whomever they have trust. So when we are talking about this a probate, so to whom it can be granted is only to an executor. Executor, as I was telling you, is the one appointed by the testator. Testator is again the one who executes the will. So in the absence of an executor, a letter of administration will be issued to a legatee, that is the beneficiary or the trustee, who has to ensure that he carries out all the directions as specified in the will. So now let me go to explain you how to make a will. So under that, I would first like to tell who can make a will. The person who makes a will, as I told you, is called a testator. The testator, he should be an adult who is having a sound mind, that is a person having sound and disposing state of mind and memory to make a will. And then it has to be voluntary, out of free will, without any force or coercion. Since a lot of elders are there. I would also like to tell, a person who is diagnosed with dementia doesn't mean he or she cannot make a will. Basically, the person should be able to understand and make a decision about the will. That is, he should have a testamentary capacity. In other words, if a person is able to know what he or she could do by making a will. So who are the
Hello.
other party? Yeah, please.
Ma'am, Ramnath sir has raised
Hello.
his question.
Hello, madam. I want
Yes,
to
sir.
know whether the will is common to all religion or only for Hindu and Christianity. The will is differ from religion to religion.
So no, a will can be executed by anybody, no matter
Okay.
whichever religion they belong to. As I was telling you, only in case of an Indian Christian, they have to obtain the executor or the legatee, they have to obtain a certificate.
Okay.
That is nothing but a certified certificate issued by the court.
Okay.
And also those who come under the jurisdiction of the presidency town when the Britishers are created. No, the three presidency towns, or one is Mumbai, Kolkata, the present Kolkata, and Chennai. So they have to go to court and apply for make a
I am
application
saying
for obtaining a
that
probate.
will is common to all religion, only for particular religion. Whatever Muslims also they are writing a
They are
will.
exempted. No,
That's
they are
why.
exempted. Yeah, yes. But what happens is, suppose if they are living in these three, the presidency towns, or if somebody is sitting in Bangalore, he has a property. When he is making a will, it also comprises of property which is falling under Chennai or Mumbai. Then yes, they have to go to court and get a probate.
Then
A lot of people are fighting.
what are the people living in other countries, USA or UK? They can create a will according to their law or our Indian law.
Sir, if he is an Indian, the question is, if he is an Indian,
Yes.
no matter whether they are residing in UK or wherever, if they own a property in India, our Indian Succession Act will be applicable. And if they belong to Hindu, the personal laws also will be applicable.
The same case as well as to Indian having property in foreign countries. Vice versa.
Yes.
Isn't it?
But again, it will also be subject to the laws applicable over there also, sir. With respect to, whether, there'll be so many laws pertaining to that particular land. So it will be subject to that.
Thank you, madam.
Yeah, okay.
Madam, I think you should complete the talk, then we should ask questions, because we are not able to get it at all. Otherwise, going on asking the questions, it's interrupting it too much. That's my suggestion. Thank you.
Okay, sure. Then when we are coming to who all would be the parties to a will. So apart from the testator who is going to execute the will, the testator would appoint a executor. That is, who has a responsibility to execute this will. As I was telling you earlier, it could be any of their family members, friends, lawyers, chartered accountant, anybody in whom they have the trust. And most importantly, while executing a will, it has to be done before two witnesses. And they have to also be a part of if the will has been executed in the form of a document as an instrument, then it has to be before two witnesses. But one thing we have to keep it in mind is the witnesses should not be the beneficiaries in whose favor the will is being made. That's very important. Now, I would also like to take you through the important details which we have to keep in mind while preparing the will. While preparing a will, it is advisable to mention the reason for doing so, which could be either due to, because of uncertainty or doubts about your your life expectancy, or it's always important to mention the reason. And also, suppose if somebody is having like 2 or 3 children, and if they want to gift it to one or two and excluding the other legal heir, then you have to specifically mention the reason, because tomorrow if any dispute arises after the testator's lifetime, if anybody has to challenge it before court, so it would be advisable to mention the reason for excluding those people who also come under the list of the legal heirs. And you have to choose the language whatever the testator is comfortable. And you can also make a provision that after their lifetime, who has to take care of their spouse. See, normally, we don't give importance to this. So we just think, Acha, this much property I own, I give it to my grandchildren or my children or whosoever. But one has to really think about their spouse, who have been all along with them in all their difficulties and their happiness, everything. So kindly people, like, we need to ensure that we have to make a provision in the will that who has to take care of their spouses. That's very important. And another thing is, you can also make provisions can be made, like so whatever if suppose somebody wants to donate their eyes, their body to a medical college, so those kind of things also can be captured in a will. And also you can also make provisions for payment of taxes for any property or estate duty, or if somebody has to recover some money from to some to a debtor, who has the right to collect it, or who has the right to collect the rent. Suppose if somebody feels that his or her daughter or son, somebody might influence immediately after their death, somebody would influence their one of the legal heir to sell away their share of the property. So you can always make provision in such a way that that legal heir would have a right to own the property, but to sell the property, it should be supported by the other legal heir's consent. So these kind of provisions are very important when you prepare a will. You can make will for anything, movable, immovable property, and it could be ornaments, it could be bonds, it could be stocks, anything. So if anyone has doubt until here, they can pose a question.
Hi, ma'am. Ma'am,
Yeah.
there is a question from Dr. Uwais Rashid. The question is, does our freedom of action has to come from a prior freedom of will? What is the psychiatric perspective about it and its impact on geriatrics? So these were the questions raised by Dr. Uwais.
No, could you just come again? Yeah, I didn't follow the question.
Okay, the first question is that, does our freedom of action has to come from a prior freedom of will?
Freedom
then
of
action has to come from a prior freedom of will. The second question, what is the psychiatric perspective about it and its impact on geriatrics?
See, one has to have an intention to make a will. See, will as such is, it has to come out of free will only. So I really didn't understand, like, if whosoever wants to pose a question to me directly, I would be in a better position to answer them. What is the confusion regarding, you're not audible.
Actually, ma'am, the question came through WhatsApp, so we'll have clarification and we will get back to you. And okay. One more question is there. Ms. Sitara has asked, what is the difference between will and living trust? And are they similar or different? So the question is in the chat. Living trusts. Ma'am, the question is in the chat box.
Mm-mm. Okay. See, a will is, you can also make a will in the form of a trust. Suppose, if there is a minor and, you want to ensure that, after your lifetime, he's been taken care well and all that. So, you can make a will and then a trust, along with that, a trust. But I would generally advise, like if somebody is making a trust, first make a trust and then you start making a will. So you can say that this property or whatever, like I own this much portion of whatever property, it has to go to this particular trust. See, will is something is created as a, what do you say, to ensure that whatever he desires has to happen after his lifetime. And whereas in a trust, you make a trust to ensure the objectives of that particular trust is achieved. See, whoever, so I'm going to the next question, that is Veena. So her question is, after death of the person, how the lawyer will come to know as the will be with children? Yeah, so basically, I would also go into this aspect of will, that is, what are the different modes of making a will. So a will can be made, you know, in a legal paper, in a stamp paper. It can be registered, it can be unregistered too. Sometimes, people also make oral will, that is, it's called privileged will for those soldiers, who would have like suffered some injuries, fatal injuries during a war. So those people can make oral wills in front of the two witnesses. So your question is, see, normally when a will is made, as I was telling you, normally they have to specify who will be the executor of that will. So you can also ensure that, the will, what has been executed, is kept in safe custody, or you can give it to a lawyer, or, even the family member, if it is at home. So somebody has to, like, uh, bring it to the knowledge of the lawyer or the other family members to ensure the objectives or enforced, which is there in the will. Could somebody ask a question? It would be better for me to answer.
Okay, ma'am, I will go
You
to the
can
next question.
unmute. Yeah.
Hello, I am Manjunath
Yes.
here. I am a
Hi,
widower.
sir.
I have only one son. So still, is it required for me to make a will? I have no one else but my son.
Okay, I'm sorry to ask you which religion you belong to, sir.
Hindu.
Manjunath, of course, Hindu. Okay.
Yeah.
Okay. Sir, what happens is, like, sometimes there will be a situation that, a person, he wants to make a will. Okay, he wants to make a will. If the person or if the beneficiary, passes even before the testator. So in such situations, to whom it has to go, you can decide in the will. So that is the advantage of making a will.
Okay.
Yeah. See, otherwise, if you're an Hindu, as per the Hindu Succession Act, it will go to if the class 1 heir is not there, then it will go to the class 2 heir. So you may like it or not like it. So it's better to make a will.
Okay. No, you mean in case my successor, to whom I want to will my property, in case he is also not there, then it will go to my grandchildren, isn't it?
So no, see, after a person's lifetime, if he is having son and grandchildren, the property, if you have died, intestate, that is without making a will, it will be divided as per the Hindu person. I mean, Hindu succession. Class 1 hires, it would be, suppose if you have a mother, it would go to the mother, your son, daughter, then son's son, son's daughter. So how many other people are there, it will be divided equally among all of them.
But mine is very simple. I don't have parents. I only have one son. He has only one son. That is my only grandson. So that's why I'm asking. In case I
Sir,
don't
as I was telling you, like, in life, everything is uncertain, sir. Like we don't know what happens tomorrow, for whom. So it's better, like, to ensure that your property, like, you can make a provision in the will that after our lifetime, it should go to my son or this much share, to my grandson or who is this much share. If anything happens to them even before this will comes into place, then you can decide to whom it has to go, either to a charitable institution or any of your friend, your relatives, anybody. So that
unregistered will is also valid.
Sorry, sir, I couldn't hear you.
If the will is unregistered, is it still valid?
Yes, it is. Registration is just optional. So but it's better. See, if you feel, in the future, if somebody is going to come and make any claim, so in that case, I feel it's better you have it registered. I think in your case, it may not be required. You can just have it executed in the front of the two witnesses. They shouldn't be the beneficiaries, of course, your son and grandson, anybody else. And then you can, you can nominate your son as an executor.
Okay. Thank you.
See, all your movable, immovable properties like the fixed deposit, they have to be listed, or it can be a general, like all my movable, immovable property, like that.
So you can, it's up to you. Like, what happens is, yes, you can, specify also, or you can mention all, or, whatever is there in whichever account, bank, everything, has to be bequeathed to one particular person. You can specify it. It depends. It's optional. But the minute you mention all, it means it covers all. Whatever belongs to you. Sometimes it's better to mention, because many of the time, children are very busy. They don't know in which account father had what amount, so it's better to list out.
Madam, good evening. This is Jambu Ma'am.
Yeah, good evening, sir. Yes, sir.
Sorry, I'm not. There can be a slight disturbance because I'm traveling in a public transport. Okay. See, I like to ask you about the common will. I mean, the will executed being executed by both the husband and the wife. The joint will. What are all the implications of a joint will? Do you suggest a joint will? Do you suggest a joint will? Am I clear, ma'am?
No, sir.
Am I clear?
No, not clear. No.
You are not, is it better now? Is it better?
Yes, sir.
Okay. See, I'm just asking about the joint will. The will being executed by the husband and wife together. And
no. First part I could understand, sir. Next one I couldn't follow you.
A joint will.
A joint will.
A joint will. Will being executed by the husband and wife together. So, I mean, is it advantageous in any way?
No, I didn't follow you. Follow your question. What is?
Sorry, madam. Sorry, because I'm traveling. See, I am talking about the joint will. Joint will.
Okay.
Being executed by the husband and wife together.
Okay.
And that will come into effect after the demise of both the persons. Have you come across this?
Sir, why, first of all, why you, I would still suggest you to make a independent will.
Well, because I have come across even big political leaders making a joint will.
Sorry?
They say that this property will be enjoyed by my property will be enjoyed by my spouse. Till that time, she cannot dispose of the property. And after her demise, the property should go to some other person. Something like that. It's a conditional will. They put certain conditions. So that is the advantage in a joint will.
So no, see, even in the will, what you're going to make individually also, you can make a provision. That's what I was telling you earlier. You can make a provision to say after, A, it can be enjoyed by his spouse, B, and after B, lifetime only, it can pass on to whosoever. All those things you can specifically mention, sir. It can be mentioned.
No, the advantage is that, the advantage of a joint will is that, certain times, occasions, what happens now, the spouse and the people and the husband they are not equally educated. And in case of the earlier demise of the educated person, there will be a problem. Therefore, the other person may not be able to execute a will or do something like that. Therefore, the advantage is that let them both of them sign the will right at the beginning and then execute the will. So that they will put a condition, we do not know who will die first. Isn't it? That's also one more contingency of life.
Sir, okay, here there is one difficulty here. Yeah, sir, in making this joint will, there is one difficulty is, suppose, A and B, husband and wife, they make a joint will. And it will be binding on both of them. And it cannot be changed after one of the party dies. That is a problem.
Okay, ma'am.
Suppose, as you know, a will can be revoked umpty number of times. Suppose you want to make a different provision after a husband dies. Wife comes into picture, or she bequeaths the entire property. And if husband has made provision that after her it can go to so and so, so and so. If at all wife wants to make a change or amendment to it, it cannot be done. So one has to bear that in mind.
Okay, ma'am. Thank you. I understand. Yes. I understand. Thank you.
Yeah. Yes, sir. Yeah. Thank you. So you can make any provision, whatever sort of provisions you want, you can make in your own will.
I understand. See, next point is about living will. Ramnath, 1 minute. Next point is about living will. Living will. That is, the person is saying that after some time, I need not be given any kind of, this kind of treatment I do not want. I wanted to die smoothly or something like that. We call it a living will. Any idea about that living will?
No, so this living will is a concept of which they follow in US.
But that is the recent judgment in Supreme Court also on that. Very recent judgment by Supreme Court on this point.
Come again, sir?
There is a very recent judgment on Supreme Court about living will. Very recent judgment. Maybe about a month or back.
So that's what. So basically, it makes provisions for, who has to bear the medical expenses, to whomsoever you are going to bequeath the property. So these details will be captured in that living will. Usually it is very, people in US, they make because they know their children will not take care.
That is right. Okay. No, see, sometimes medical expenses are also shooting up like anything nowadays, even in India. So to avoid certain types of legal,
Yes.
So
it's good. It's important. Yes, sir.
Yeah. So that's right. Thank you.
True, sir. Thank you, sir.
Hello? Hello, madam?
Yes, sir.
Hello? Ramnath here?
Yeah,
Madam,
yes, sir.
can the will can be executed in the presence of notary public or judge or anything, or any with the two witnesses will do? Or the next question is, the will can be executed. That is, if you one person having two wives, no, first wife is married or second wife is accordingly they will how they will create the will. First wife and second wife like this or common will. Two questions.
So let me answer your first question. So basically,
we executed in presence of notary public or
yeah.
Advocate.
So no, it can be before any two witness. It can be anybody. Your neighbors, your relative, your friend, anybody. It need not be. It has to be before any district judge. No, there's no such requirement.
Only in case both the other persons are necessary, isn't it? Required. Case of registered.
No, I didn't follow you, sir.
In case of registered will,
come again.
You have to go to the court or representative office, isn't it? In case of registered will, not ordinary will. In case of registered will, go to the court or the thing. Okay. In person notary public.
So normally, people prefer a will to be registered is where there are any suspicious circumstances, surrounding, the execution of the will. For example, an element of fraud, coercion, undue influence, lack of capacity. It was not for want of free will or consent. If somebody challenges it, and if it was not voluntary or it was revoked thereafter. So at those times, to ensure these kind of things, doesn't really hamper in the way of, whatever in the execution of the will. So people prefer having it registered. It is just optional.
Okay. So what about the second question? The second question.
Yes,
will can be created by first wife, then second wife, or first
sir,
wife
you can. No, sir, I didn't follow your question, sir. If you could repeat it again.
It can be created to anybody. Suppose
so you can, in a will,
two wives, no? The preference will be first wife or first wife and second wife, or only first wife immediately, and then second wife. Both eligible?
Sir, it is up to you. It's up to the person who wants to make the will. Because he can even give, he can leave both the wives and he can give to a servant also.
Thank you. Yes, thank you.
Yeah, yes, sir. Yeah. So will need not be necessarily to the family members. It can be, executed in favor of any friends, relatives, as I was telling you, any mutt, charitable institutions, anything. So whomever we decide.
Okay.
Yeah. Yes, sir.
Madam, you told no, you have to register when we do it in a secrecy, and we the person we have noted for nominate for the this property may not be known that I have done will towards him. So how he can come to know that he has the property of will from me, like that?
I mean, basically, as I was telling you, well, that is why I told what are the important things which has to be captured in a will. You have to ensure that you appoint an executor. So executor again should not be, what do you say? Sorry, he can be even the beneficiary. But to avoid, as I was telling you, if there are 2-3 more people, 2-3 more legal heirs who also have a right, if the person has died intestate, in that case, you could, have a third party or a friend or a relative as an executor or a lawyer, anybody. So basically, at times, somebody will make a will, and then they'll just leave it in a cupboard, or, unknown to anybody. So those are the situations, where all these disputes arises. Like people would have partitioned the property, and thereafter, somebody takes up, finds this will. So that's a reason it's always better to appoint an executor to avoid all these things. And sometimes nobody can find it also. At least
Okay,
it should
thank
be
you,
within
madam.
the knowledge of the beneficiary.
Yeah. To safeguard that person, if I noted the another person, my sons my known person may not know, like, because I have been giving to my property to that person. That is safety purpose. We can't say also, no.
No, ma'am. Could you just
For the
repeat it
safety
again?
purpose, whom I have nominated, I written the will for his name, towards his name.
Okay.
That may not be liked by my this one siblings, may not be liked by my siblings. Apart from them, I have written to somebody else. No. So for his safety, I would not have told to my siblings. Before, if I told before, they might pressurize him not to take a will and make another will from my side, like that. To avoid these misunderstandings or some willings, how it can be clarified?
Ma'am, as see, when you're preparing the will, as I was telling you, if you want to exclude somebody from the will, you can always specifically mention if you have a strained relationship with them, or if you feel, they have not contributed for any family maintenance, or whatever it could be the reason. It's better to specify the reason. If they are one of the legal heir, better to specify why you're not including them in the list. And so to whosoever favor you are making, that is the beneficiary, you can ensure that that beneficiary at least knows that you have made a will. Even if he or she has not been made an executor, at least even if you have given the document to your lawyer or some chartered accountant or a district registrar, at least ensure that the beneficiary knows about it.
Okay,
Tomorrow the lawyer and the sibling shouldn't try to hide the will. There are chances if it is not registered. So it's always better to have it registered.
Where it can be registered, ma'am?
Ma'am, it can be registered anywhere. Like, if you are in India, if you are outside, suppose, you reside in Bangalore, and you have few properties, not only in Bangalore, also in other states. So you can mention, make reference of those properties also in the will, and you can have it registered in Bangalore.
Registered office, like that.
Wherever you reside, basically wherever you reside.
Nearby, we have to register in the registered office.
Yes.
Okay, ma'am. Thank you, ma'am.
Which office? Which office? Registration.
Which office?
That is what actually.
So normally, whatever the property and all you register, sub-register office.
Okay.
So normally there will be there won't be a stamp duty. See, if at all you're revoking, that is, once you made a will, then after some years, you have bought another property. So you want to add that property also into this will. So that time you will be revoking the old will. So at that point of time, there is a minimal stamp duty of some 100 rupees in Bangalore. And then, nominal fee of registration.
And they will be given one copy, like that, ma'am?
No, not copy, ma'am. The original will itself you will be having with you. So normally, once you're registering the will, it will be scanned. All the documents will be scanned. So whosoever want to challenge it, it is, since it is registered, it will be scanned. You can always obtain a certified copy and furnish it before the court, if at all somebody challenges it.
So we'll be having certified copy that we have registered, like that I'm asking.
No, the original will be with you only. You
Original
can give it to
will
anybody,
be
the
with
beneficiary.
me, no? Original will
Yes.
be with me, no?
Original,
So when
either you can keep it or you can give it to the executor whom you are going to appoint.
So certified copy will be there. If I registered from that office,
Yes.
I'll get the registered copy.
Yeah, see, when you are registering itself, you will be getting the registered copy with you. The original will be handed over to you. So you can decide. You can give it to your lawyer, you can give it to your family member, your spouse, anybody, children.
Okay, ma'am. I got clarified.
Whom you feel will be executing it after one's lifetime.
So it is registered is safe, I feel.
Yes, registered is safe. If at all you feel, you apprehend that, somebody would come and challenge any legal hair or anybody, it could be anybody, they can say that, this property actually belongs to me. So many things, actually I had only contributed, for buying this property. So many things will come up.
So after registering also, will can be made, another will can be made because of out of pressure or some
Yes, ma'am, bill can be made how many ever times. There's no limit at all. You can keep revoking.
See,
so
madam,
cancelling that, you have to make another one.
Yes, but yeah, whenever you're making another will, you have to always say that this is your last will. That you have to specifically mention in the will, the draft of the will.
See, madam, recently my mother-in-law died. She had prepared a unregistered will in favor of her two daughters. There was a property in Kerala. The registrar insisted on family tree or the legal heirship certificate. So despite having a will, the registrar can insist on a family tree.
No, so have you gone to court for what purpose, sir?
See, my mother-in-law died. She had some property in Kerala. So she had written an unregistered will giving everything to her two daughters. Despite that, when we sold the property, but the registrar insisted that you produce a family tree or a legal heirship certificate. So is it a compulsory?
No, who is asking that?
The registrar who has to register the sale deed.
No, there is no requirement of executing a sale deed, sir. See, after the, in whosoever name the will has been executed, you can have the kata, transferred to their name. For executing the sale deed, the person should be alive.
So, madam, probably what she is asking is, after the will has been executed, these two daughters are joining together and selling the property. In such a situation, the that is what his concern is. I'm also coming to the same problem, madam. See, what is happening is, is it necessary for us to approach a court of law and get a probate in every case, so that the local authorities change the property name to our legal aspect?
So, sir, sometimes, no, actually it is not required. I just told you in which are all conditions, where it is required to obtain a probate. Not in every case. So one has to, in this case, one has to just prove that, that so are the daughters of the lady who is a testator, who executed the will. So I don't think so there's any requirement to say, like who are all the legal heirs and all those things. because it
Not
doesn't
only
come into
the
picture.
death
See,
certificate will be
since
sufficient.
it is an unregistered will, probably, the sub-registrar would be like, would be keen to know as to who are all the other legal heirs. If at all, what happens is, suppose if somebody wants to challenge it, imagine, that lady had another son or, some other, husband or somebody. To their exclusion, if somebody has something else have been prepared. So they would like to know who are all the other legal heirs. So it's a genuine thing only. Just to ensure that tomorrow nobody else will come and question. If somebody challenges the, will. So to be on safer side, she would have insisted for it.
Madam, may I ask you one question? Suppose if
please.
Some bank account, suppose I do not know what will happen tomorrow to me. So my bank accounts, there is, I mean, some amount is there. And in case if something happens to me, then tomorrow, how it will be operated by
will.
For that also we need to include any will.
Ma'am, that's what, see, what happens is if you're not executed a will, we were talking about the immovable properties. Also for movable properties, if you have not executed, if somebody has not executed a will, then they have to go to court and obtain a succession certificate.
Okay, so
it's a
that
very
is
lengthy procedure.
A long process after my death. Also, it's a long process for the siblings, right?
Yes, exactly, ma'am. So that's the very reason it's very important to execute a will.
So including the FDs and bank account number and everything.
Yes, you can mention. Yes, all your belongings, movable, immovable, stocks, debentures, ornaments, gold, everything you can specify.
It should be registered also.
Yeah, have it registered also. Yes. See, in
So
some cases, yeah, tell me, ma'am.
So the same registrar office only it will be done, right?
No. See, suppose today you're in some other area, you do it in one particular area. You can revoke it anywhere. Need not be the same sub-registrar. So you have to make a reference saying that this was my old will and you're revoking that and now you're executing this, then this would be your last will and testament.
So my legal heir, suppose my daughter, I'm handing over the will to my daughter saying that this is the thing I have got with me, which I want to hand over to you in the future. So I can inform her and keep it there, right?
Yes, ma'am. Yeah.
So she is highly eligible to get it. Am I right?
Yes, definitely. Yes, of course.
Okay. Thank you. Nice.
Yeah, welcome, ma'am. Yeah.
Madam, lastly, one question. For execution,
no problem.
For probation, etc., probation of the will, etc., what will be the stamp duty? What will be the cost, madam? Cost of that.
Sir, it depends upon your lawyer, sir.
No, but that is the stamp duty that is common, isn't it? Stamp duty is there, isn't it? Some stamp duty needs to be paid to the court.
Sir, it is a certified, copy or a, of a will which will be given by the court. So charges, I think you have to check up with your counsel, sir, whoever you would be going.
Madam, I'm told it goes up to 10% of the property value. I do not know whether it is true.
Sorry?
It goes up to 10% of the property value. People are telling.
Yes. It depends upon, in each state, it is different percentages there, sir.
No, it is usually about 10,000 rupees, not 10% of the salary, the total property. That will be enormous. I've recently done it. It's about 10,000 rupees.
Sir, it differs from different state to state, sir.
It is so.
There are some percentage also.
Yes.
There are some percentage also specified.
In
5% to 3%.
Madam, in bank deposit, they ask for nomination. So whether will overrides nomination or nomination overrides will?
Will.
Madam, will always override the nomination. Because will is the final right. Nomination
Yes, that's
only
the last
that,
one.
Yeah, that is super is will.
Yes, sir.
And in fact, there are many Supreme Court judgments where they say that nomination is only deciding, nominator is only, the nominee is only a person who will distribute the wealth. That's all. He is nominated to take the money from the bank. But it doesn't mean that he is the sole beneficiary.
He will own it. Yes. Yeah.
Yeah. That is, that kind of, so many judgments are there on that point.
Very true, sir.
Thank you. You are practicing in Bangalore or elsewhere?
Sir, I'm in Bangalore, sir. I stay at Rajaji Nagar.
Oh, Rajaji, excellent.
Yeah, I am also one more question. So in the bank accounts and all, they are taking the nominee's name, right? We are giving the name of the nominee. Then the nominee cannot take over that instead of showing the will to anybody. Is it required? Is the will required?
No. For what, ma'am?
For bank accounts.
FD, yeah, I got it.
And my savings account and all. So the nominee, anyway, we are giving the name as a nominee, right? So the nominee can also has the right to take care of things, right?
Yeah, sir, as sir was telling, for collecting, yes, of course. But if you have made a provision in the will to whom it has to go, then it will go, the rights over that particular value will go to that person only.
So how the people will come to know?
Well, that's what, see, when you go to bank, definitely all these questions and, everything will be asked, no? They will also verify, make a verification.
Okay. Ma'am, can you
so
share
the person, whoever is the...
If we have any doubt, we can
yeah,
ask.
Definitely. Yeah. Yes, definitely, ma'am. You can take down my number.
Yeah.
It's 9845.
1 second. 9845.
190.
190.
949.
949. 9845 190 949. Am I right?
I'll just repeat it, ma'am. 9845 190 949.
Exactly.
Madam,
okay, madam.
You put it in the chat box also, madam. You put it in the chat box also. So that Leena ma'am can, or Leena or the person who is whoever is moderating the session can also note down and just put it up, so that any person who needs certain other clarifications also can get it from you.
Yes. Thank you.
Thank you.
Excuse me, madam.
Yeah, tell me, sir.
After the death of the officer, wife has to make the will.
Come again, sir. I didn't follow you.
After the death of the officer, he is an officer and retired. His pension is there, and wife has no property, but the property in the name of the officer, whether his wife is eligible to make a will.
Sir, what happens is after the death of that officer, she will, she'll become one of the legal heirs. if that person had children and grandchildren, so she can execute a will to the extent of her share in that property, what she's going to get, not on the entire property.
Okay. Okay, thank you.
Yeah, yes, sir. So that's why it's better before the person, he passes away, better, they make a will.
Yeah.
So earlier, they used to say that, when a person is, nearing, 50s, 60s, they have to think about it. It was like a ritual, it has to be performed during the sunset years of a person. But it is prudent to prepare a will as early and have it revised as many times you want, if you find it necessary, as life advances. So I think it's better in this kind of a contemporaneous situation, it is advisable to make a will, sir.
It was a COVID situation.
Exactly. So, nowadays, many youngsters, everybody are, coming to us for executing a will. And many of the, people who are in IT and many various other fields, to secure their parents and under Hindu succession, if a male, is died, as per the succession, it will goes to the mother and wife, children, not to the father. Suppose if mother is not there, it goes only to the wife and children. So what happens to the father who has really, taken care of him all along? So since these kind of things are there in the law, so it's better to, ensure your desires are taken care.
Yeah.
By executing a will.
That's a very sound advice, Dr. Madam. Because this is the real
Yeah, thank you,
situation.
sir.
Only, yeah, that's a very sound advice. But in fact, I will add only one thing, madam. Recently,
Yes,
government
sir.
of Tamil Nadu has passed one amendment. There they are making even the father also as a class 1 legal heir, along with the mother.
Yeah.
Along
Yeah.
with the mother.
That should be that
that
should be there, sir. Definitely.
It has been done. But anyway, writing a will is the best option, madam. So the process is very simple and it is cost effective also. The best way to transfer one's property without spending money is writing a will only.
Yes,
So
yes.
then there is absolutely no doubt. No doubt. No doubt.
Yes, sir. Yeah.
They can go to court by Mama Gopal Bhatt, Nasgam Zamte, Nasgam Gapra. Upon us, actually,
So thank you, madam. It was a wonderful session.
Madam.
So you explained all the doubts very clearly, madam. Thank you. God bless you.
Yeah. Thank you, sir.
Namaste,
Thank you so
madam.
much.
Namaste. Namaste, madam. I have some property with my name. So without doing the will, if I expire, to whom it will go? To my husband or my siblings, like that?
Ma'am, it depends. It depends upon your religion again, and also if you're an Hindu. Okay, so what happens is, suppose if it is your self-acquired property, then of course it will go to your husband and children. Suppose that property has come to you from your parents' side.
One side from my mother, one side is gifted from my husband. I have two sides. And my mother has given for some lakhs. Financial.
So what happens is, in those cases, your husband will be excluded if it has come through your mother's side.
One side is from his side. He has gifted me one side.
Yeah. So whichever has come from your in-laws or from your husband's side, that will go to your husband and your children. But if it has come through your maternal side, yes, then your husband will be excluded. So that's a very reason, you have to make a will.
So that amount and property goes to my siblings, huh? Mother side property goes to siblings.
Yeah.
Okay, ma'am. Because but I have done nominee into everything for my husband name only. I've taken lot of shares and funds like that. For that I have made him joint account, and also after my this one that should be continued by my husband like that. So for that specifically it comes out of them after without making a will. Accordingly, will they do like that? They will.
Yes.
Acquire.
If you have made a nominee, yes. But I would still suggest you to make a will, ma'am, to have a clarity here.
Excuse me, ma'am. This is, I have received a property from my mother. It was gifted to me, and I have made a will and registered it too, to go, that it should go to my daughter. So it should not create any problem later, isn't it?
Yes, it wouldn't, ma'am. Yeah. So if you're making a will, very clearly you're specifying it, for whatever reason, then it shouldn't create any issues.
My siblings will not create any problem.
Yes.
They cannot.
Yes.
Oh. But it has been registered, but I have not specified that to, I have just, as you said, I kept in the cupboard. How I should...
Better you have it registered, no?
It is registered. It is registered.
If at all you apprehend.
It has been registered.
Sorry?
It has been registered.
Okay, then it's fine. Okay,
but how I should let people know about, somebody should look into it, how I should give it to my daughter.
So you would have, you can give it to your daughter, absolutely. Yes, since it is registered, so you can give it to your daughter.
Okay. Thank you.
Yeah, welcome. So, and one more thing, important thing, what I would like to tell is, suppose, if anyone has reached, see, earlier and all, people who have crossed 80, if they are going to make a will, they used to insist that, it has to be, somebody has to certify that that person is capable to understand what he's making by, a certificate issued by some government doctors and all. Government, those who works in the government hospitals. So this is also something very crucial, nowadays, even people who are above 60, we normally insist them to get such certificate. Testamentary capacity certificate.
I want to sell
even for 60 years. Even for 60 years more.
No, I would suggest, sir, because tomorrow what happens is, somebody will say, no, my mother or father, they had this issue, so they were not in a position to actually take a decision. They would have threatened, they did this, that, any kind of a thing they can come up with. So to avoid that, to be on a safer side, to get such a certificate.
I agree.
Normally, the court will not consider, but it's for us to be on a safer side.
Yeah, the legal process can be fastened. Can be quickened, can be fast. Otherwise, on all these issues, the court will just take lots of time, and the things will not get settled. Yeah, that's the whole problem. I understand.
It should be that the person was mentally sound and maintaining good health. All this should be, a certificate should be attached to it, or it should be mentioned in the will itself.
No, you have to obtain. Yes, you have to obtain a certificate. It has to be a part of your will.
And also, when you are, is it? It is an separate paper.
Yes.
Okay.
Yes.
Mentioning the date,
which is a supporting document. Yes, and also when you're drafting the will, also you have to make a declaration in the will saying that you had a sound state of mind, health, memory, and you're doing it out of your own free will and volition. In the those kind of a thing, it's better to specify.
Okay.
And if there are any guardians or any beneficiaries, their names, everything you can clearly specify here.
Okay.
To make it short, it's better to draft it in consultation with the lawyer, so that things will be easy to execute.
Yeah, because it is not as expensive as one does with any other property dealing. So this will be a very, very minimal cost.
Exactly, exactly. It's always better. I understand.
Yes, sir.
Ma'am, when I did my will, they did not ask as per percentage. They took, just as one of the person mentioned, certain thousands of rupees only. There was no percentage as per the value of the property.
No, there is no percentage, ma'am. There is no percentage. There are some just nominal fees. That's all. There is no percentage, and there is no stamp duty also.
For execution of bill, there is no percentage. For for getting a probate of the bill from the court. See, that's something totally different.
Then
this is executing the bill before the sub register. There is some fixed charges for bill writing charges or something like that. That alone is taken. That when you are when you are probating that bill in the court of law, so that the bill becomes effective before the person who should dispose of your property. Supposing it is a fixed deposit, it's the branch manager who has to take a decision about giving the property to the next of the legal hand. For that, at that time, the probate may be needed. For that only, you have to approach a court of law. So the court of law always charges certain percentage. They have got some stamp duty payment, and lawyer also charges something for that. That is what I mentioned. Am I clear, ma'am?
Okay.
Yeah, very true, sir.
Thank you. Thank you.
Perfect.
Hi, ma'am. So as we are running out of time, I think we can conclude the session. So if there are no queries, okay. So first of all, I would like to thank all the participants for their interactive session. Like they really participated well, and they had a lot of queries on like probate procedures and provisions of making a joint will. And there were queries on the movable and immovable properties, and is it compulsory to register the will, and modes of making the will, a lot of queries. So ma'am gave a really beautiful answers to all those questions. So I would like to thank ma'am for her time and energy for this session. Thank you, ma'am. Thank you so much. So over to you.
Thank you, madam. Thank you so much for giving an awareness towards will.
Well, I should thank everyone for accommodating me and to address you all this wonderful audience. So it was really a pleasure, ma'am. And thank you so much.
Thank
you.
If
anyone has any doubt, please you can WhatsApp me or you can call me also.
Okay.
That's
thank
nice
you.
of you, madam. Nice of
Thank
you,
you
madam.
very much.
Thank you.
Yeah, in fact,
Great. Thank you so much.
Yeah.
Thank
you
you.
have spent a lot of your valuable time. You have spent a lot of your valuable time, that too on the evening, where you will be practicing. So thank you very much. So we'll
Thank you, sir.
certainly
Thank you
reach
so much.
you.
This is the right
You,
age, and
surely.
this is the right age and stage where we really require this information, and you have given that to us. Thank you.
Thank you, ma'am. Thank you so much. Any doubt while even drafting a will, even if you have gone to a lawyer, that's okay. You can still share me the draft. I can, if any input has to be given, I'll definitely help you all.
Thank you.
Thank you, ma'am. Very nice. Very nice.
Yeah. Thank you. Thank you so much.
That is wonderful.
Thank you,
That's
sir.
wonderful.
Thank you.
Wonderful. Thank you.
Thank you, Ansela, for moderating the session and your support for us. And I would like to thank Ragamalika ma'am for the informative and enriching session for us. And I would like to thank all our YouTube and Zoom participants for joining with us today. With that, I would like to thank our partners, Government of Karnataka, Indian Psychiatric Society Karnataka Chapter, Karnataka State Legal Service Authority, Bangalore Apartment Federation, Happy 60 Plus, Samadhana Counseling Center, Icon Life Sciences, REC Foundation, NEC Foundation, and Nightingale Medical Trust. Once again, thank you all. Have a good evening. Thank you.
Thank you so much. Thank you.
Thank you. God bless you. Bye.
Thank you, sir. Thank you so much. Thank you.